Lucy Letby is accused of the murder of
7 babies and the attempted murder of 10 others.
While she was working on the neonatal unit at the Countess of Chester Hospital.
Letby denies all of the charges over the incidents.
Lucy Letby was the only person working on the night shift. It was alleged in court that their mother was apparently told by Miss Letby, "Trust me, I'm a nurse."
This is a podcast about one of the most anticipated criminal trials for years. It involves the most shocking of allegations: the alleged murders and attempted murders of tiny, premature babies at the hands of a neonatal nurse whose very job it was to look after them.
Lucy Letby is on trial at Manchester Crown Court, accused of killing 7 infants and injuring 10 more at the Countess of Chester Hospital in Cheshire.
In total, there are 22 charges, all of which she denies.
I'm Liz Hull, Northern correspondent for the Mail. I will be in court to report on the case as it develops.
And I'm Caroline Cheetham, a broadcast journalist. Every week on this podcast, we'll examine what's happened and bring you the details behind the headlines.
This is the trial of Lucy Letby.
The case against Lucy Letby is that she murdered or tried to kill 17 babies while she was working as a neonatal nurse at the Countess of Chester Hospital in the northwest of England. She denies the charges.
The babies in this trial are not being named for legal reasons, and the identities of their families are also being protected. They're known only as babies A to Q.
7 of the babies died. 10 survived. Each one of these babies was or is someone's son or daughter, and the mums, dads and families of every baby are present in court, listening to every detail of how their child was allegedly killed or harmed.
We'll be bringing you that detail as the jury is hearing it from the prosecution and defence. We're getting behind the headlines to explain far more than the news reports you'll be reading, watching and listening to. And the importance of a fair trial is paramount, so we won't be getting into anything in this podcast that the jury have not been told, because they are the 12 people who have to decide the outcome of this case. Welcome to episode 10. So we're back, Caroline, after the Christmas break. The jury have had a few weeks off and evidence starts again with the focus on the next baby in the case, baby H.
Baby H is a baby girl who Lucy Letby is accused of attempting to murder twice in September 2015.
We'll bring you the detail in next week's episode, but for this week we're joined by Mark Hanna. Now, he's one of the editors of McNae's Essential Law for Journalists. Do you want to just tell us a bit about McNae's, which is what journalists call the law Bible for our profession?
The McNae's book goes back to 1954, when Leonard McNae, who worked for the Press Association as their, special reports editor, he produced this book with others contributing to it, setting out the media law as it was at that time, and the book has continued over the decades. It's now in its 26th edition.
And it really is a Bible for journalists, isn't it? I mean, when I did my training, everyone goes out and buys a copy. I mean, I've been in hearings where I've stood up or the PA reporter stood up and said, hang on a minute, you can't hold this bail hearing in private, this is why we object, or hang on a minute, we don't think it's right that you put this reporting restriction on, we have a right to report this case. And everyone is like Googling McNae's. I mean, you used to have one in your bag, but now everyone, or at your office, but now everyone is Googling, because getting up in front of a judge is pretty terrifying. So you want to make sure you get it right.
Yeah, I mean, the law has got more complicated in the sense of there being more statutes passed over the years which impinge on what journalists can or can't do.
I think my first one is about half the size of this new one that I bought over Christmas.
Yeah, there's greater anonymity provision, for example, for victims of forced marriage and female genital mutilation, for example.
Yeah.
Those anonymity laws have increased over the years. Quite rightly, journalists don't object to them. But you need to know whether you're a feature writer or a court reporter or on the news desk, you need to know when a story could involve a restriction in the sense of someone's identity must be protected. So it's not just court reporters who need it, it's anyone who's involved in frontline news reporting or feature writing.
In terms of how hard it is, from your perspective, to keep up with the changes, is that sort of getting easier? Are there fewer changes than there used to be? Are there more? Where are we with sort of the pace of change?
I think different editions have different content to deal with. For example, when we started, Jon Harris is the co-author. When Sean and I started this edition, it was towards the end of the pandemic. We thought not a lot would have been done because of all the pandemic, when actually there were a lot of changes, some of them induced by the pandemic, affecting reporting, defamation cases, privacy cases where judges lay down new principles. You always have to check the statutes in case there's been an amendment. Sometimes we discovered an amendment affecting reporting which hasn't been announced by the government. I think it has got more onerous because there are more statutes involved. And also, media regulation has become more important.
I mean, we've talked to previous guests we've had on the podcast about the kind of decline, I suppose, in court reporting. The fact that the focus has changed in a lot of media organisations, I mean, due to the fact that court reporting is quite expensive, because having a reporter at one court all day to report on a single case when they're only producing one story a day in this kind of like 24/7 global news that we live in these days, sometimes some news desks think, well, they'd be better off sat at their desk writing 4-page leads for me.
Yeah, I think there's a lot of anecdotal evidence about this. In a big city in the old days, there could be more than one newspaper and a freelance agency, but the number of freelancers who attend courts regularly has declined because there's no money in it for them or they retire. In terms of figures, we have, I don't know if any of your previous contributors have mentioned, but the Cairncross Review, which was an official review of journalism, found in 2019 that the number of frontline journalists in the UK declined from 23,000 in 2007 to 17,000 in 2019. And we're still swiftly declining. So that's a fall of, a quarter.
In terms of journalists knowing what the law is and knowing any updates in the law and all of that, obviously our job as professional journalists is to follow that and make sure that we're doing the right thing, often based on what's in your book. But your book isn't governing the internet.
Well, law does affect what's published on the internet. You can be fined or jailed for what you publish on the internet. One of the changes in the law is how internet publication affects what can be reported, and the law's changed to some extent to cover internet publication. Judges are worried when a Crown Court trial begins whether the jury will do its own research onto the internet, and juries are very firmly warned against doing their own research. So yes, the book does cover the dangers of what you publish on the internet, although obviously there's a difference between what a journalist knows about the law and what the man or woman in the street knows about the law. They may break the law without realising they're doing it.
That was the distinction I was making, really. Not that your book doesn't cover the internet, but doesn't probably cover the people who don't read the book or don't train as journalists or don't understand that law is really, really important for loads of reasons.
Well, people have been fined for identifying victims of rape on the internet, but of course that's illegal.
Yeah.
So maybe schools could do a little bit more if they're doing anything at all. And when they tell people about social media and the dangers of it, which of course are manifold, they could point out that some things are illegal.
So obviously, Mark, the podcast is covering a live trial, which is challenging and terrifying in joint measure for us. It's really interesting that we're doing this summary of each week's evidence, but we're acutely aware that this is a multi-million pound trial, and we've got to be very careful with whatever we do to make sure that we're reporting it correctly. Just to explain to the listener for us, would you, what rules govern our reporting of a live trial, I suppose?
Yeah, sure. The two main things in the forefront of the reporter's mind, apart from any particular reporting restriction about who can be identified, it's the law of defamation and the law of contempt. So both of those laws, and there's the Defamation Act 1996 and the Contempt Court Act 1981, they both require reporting of cases to be fair and accurate. And obviously accuracy is self-explanatory. Fairness means that the reader is not misled by the report as to what was said or is happening in the case at the trial. So if a reporter makes a mistake, and it's a bad mistake, it could be that someone in the trial could sue them for defamation. For example, if they say someone was convicted when they're acquitted, then obviously that's a terrible mistake. But just misquoting witnesses, or indeed judges, could mean that the witness or judge could sue for defamation because it's made them look bad and affected their reputation. Contempt is a different priority. That's to maintain the integrity of the justice process, to make sure that people get fair trials, for example, and that justice is done. If there's a bad error, the judge may well be able to remedy it by explaining to the jury, one, they shouldn't be reading media reports anyway, but if they have, then this was an error. What is the most dangerous, I think, is to write into a trial report extraneous material, something that was not said at the trial. And the trouble with a complex trial, as you know well yourself, is you have a lot of information in your head about this case, which may not be related to the jury because it's not appropriate. They don't need to know it for the trial. And in fact, the judge had made a ruling that the jury should not know certain information because they don't need to know it when considering their verdicts. But if you, by mistake, put that material into the trial report before the verdicts, and there's any danger that the jury either read it or could be told about it by their families or friends, then that could jeopardize the trial. And there have been instances. The most famous incident was in 2001 when a trial involving Leeds footballers was abandoned. They were accused of violence to a man of Asian heritage outside a nightclub, and the judge had ruled that no evidence should be given that this was a racial attack, because he ruled that there wasn't any or strong enough evidence for that. But the Sunday Mirror, at a time when the jury was still considering its verdict, published an interview with the victim's father in which he said it was a racist attack, and that meant the trial was abandoned.
It cost the Sunday Mirror quite a lot of money, didn't it?
It did, yes. They were fined, I think it was £75,000 contempt, but the editor resigned as a consequence, Colin Myler. So it cost him his job. And the cost of the abandoned trial, because there had to be a second trial, the cost of the first trial was over £1 million.
Yeah.
After that, the government passed a law, which is in the Courts Act 2003, saying that if there was serious misconduct, in effect causing a trial to be aborted, whoever had committed the serious misconduct could be required to pay the cost of the abandoned trial. We should say that the Leeds footballer Lee Bowyer was acquitted of the charges, and the other one, Jonathan Woodgate, was acquitted of the main charge, but convicted of a fray.
Are you aware of another podcast of an ongoing trial week by week like this?
No, I haven't. No, because obviously, as you say, you need good legal advice. I think it's good that you're doing it because court reporting is important, and as we've heard, it is kind of under threat because of lack of resources and for other reasons.
Next week, in episode 11, we'll outline the evidence the jury will hear over the next few days about baby H. Lucy Letby denies all the charges against her.
We'll also bring you the second part of Mark's interview, where he'll walk us through new rules which allow some court cases to be dealt with behind closed doors. It's causing a lot of concern and has been called an affront to open justice. So it's a really important change which Mark will explain.
I'll be in court to listen to the evidence, and you can read my daily reports in the Mail and on Mail Plus.
You can also follow us on Twitter at Lucy Letby Trial, or send us an email at thetrialoflucyletby@gmail.com.
And we'll both be back next week. See you then.
Lucy Letby is accused of the murder of
7 babies and the attempted murder of 10 others.
While she was working on the neonatal unit at the Countess of Chester Hospital.
Letby denies all of the charges over the incidents.
Lucy Letby was the only person working on the night shift. It was alleged in court that their mother was apparently told by Miss Letby, "Trust me, I'm a nurse."
This is a podcast about one of the most anticipated criminal trials for years. It involves the most shocking of allegations, the alleged murders and attempted murders of tiny, premature babies at the hands of a neonatal nurse whose very job it was to look after them.
Lucy Letby is on trial at Manchester Crown Court, accused of killing 7 infants and injuring 10 more at the Countess of Chester Hospital in Cheshire.
In total, there are 22 charges, all of which she denies.
I'm Liz Hull, Northern correspondent for the Mail. I will be in court to report on the case as it develops.
And I'm Caroline Cheetham, a broadcast journalist. Every week on this podcast, we'll examine what's happened and bring you the details behind the headlines.
This is the trial of Lucy Letby. So last week, in our first episode back after the Christmas break, Caroline, we heard from Mark Hanna. Now, he's the editor of McNae's Essential Law for Journalists. And this week, we had been hoping to bring you details of evidence heard by the jury during their first week back. As often happens in long and complicated court cases like this one, we get delays. And once again this week, one of the jurors was poorly and another had a family matter to deal with, so they didn't actually sit at all last week.
So the long and short of it is we haven't got any evidence to bring you. But luckily, we're going to hear more from Mark Hanna, and we've also lined up another great guest to speak to, Jon Harris, the legendary boss of Cavendish Press.
Welcome to episode 11.
In the first part of Mark's interview last week, we heard about the challenges journalists face covering court cases. In the second part today, he tells us about a new procedure that means some cases are not even heard in public.
Well, the backdrop to this is the austerity years when public spending was cut. The Ministry of Justice suffered a very big cut over 10 years. I think it was nearly a quarter of its budget. So they looked at ways to what they call modernise the system, which basically means to cut costs mainly. So the government of the day in 2015 passed law enabling what we now know as the single justice procedure.
And in layman terms, that's essentially kind of like secret hearings.
Yes. What it is the government presented this as dealing with kind of low-level cases in magistrates' court, such as speeding, TV licence evasion, train fare evasion. These were dealt with only by fines, not imprisonment. And under this law, there doesn't have to be a court hearing at all. A notice of prosecution is sent to the person accused, the defendant. They can plead guilty or not guilty. If they plead guilty or don't respond, for those types of case, there's no courtroom hearing. It's dealt with by a single magistrate sitting in an office, basically, looking at the evidence and if anything has been heard from the defendant. Now, these kind of low-level cases used to be in open court, and it may be that journalists didn't attend them very much, but the point was they could if they heard of a local dignitary or celebrity, or they could just wander in and listen
and
to
pick it up
and see if anything was newsworthy.
Yeah.
But now they can't because it's an administrative process. There's no court hearing at all. Lists are sent to journalists, or should be, saying who's due to be dealt, and there should also be a register sent saying what the outcome is. But what journalists don't get, unless they write in by email to apply for it, they don't get the evidence and they don't get any mitigation. Now, some journalists are doing that. One in particular, Tristan Kirk of the Evening Standard in London, has pioneered this. And the law does allow you to write in and request the prosecution evidence and any mitigation. But it's turned into an investigative process, if you like, whereas before you could go along and hear it, and now you have to apply for it. It can take weeks.
It's onerous, basically, for journalists to do it, isn't it?
It's much more whether a journalist hears of an individual case that they need to pursue. They don't hear of the case, and they don't get the register. Sometimes these are not sent out, or they don't recognise the name on the register because it's a celebrity or someone using their real name, not their stage name.
Yeah.
Then the case can go completely unreported. In fact, Tristan found out over 1,000 cases had never been publicised at all, including 2 policemen who've been fined under the COVID regulations for not obeying quarantine coming back from abroad. These cases weren't publicised at all until he started digging.
That seems to have snuck under the radar.
Well, I think when MPs passed this law, they were told it was for what was known as straightforward, victimless crime. The nature of the crimes being dealt with has kind of spread out from what MPs, I think, understood. For example, truancy cases are being dealt with in the single justice procedure, whereby a parent is prosecuted because a child doesn't attend school. It could be that there's a wider issue here. Was the child being bullied? Is the school looking after the children as regards bullying? And these cases are now virtually being unreported.
Okay, Liz, so Mark Hanna there was talking a lot about changes in court cases, and we've heard a lot on the podcast about changes in access to courts and the number of trials that are maybe not covered in enough detail. And we've got the most amazing guest on to talk to us a bit more about this, haven't we? I mean, I can't think of anyone better than Mr. Justice Jon Harris, as he's known.
As he's commonly known in the Northern Circuit of journalism, we should say.
Jon, introduce yourself. Tell us why you might be known by that name and what you've done in your career.
Okay, my name's Jon Harris, and I'm the principal at Cavendish Press, which is a news agency which sources stories and pictures for various newspapers, websites, magazines, etc. The reason for the Mr. Justice nickname is because for many, many years our agency has covered primarily court cases, tribunals and inquests.
And a lot of our podcast so far, in the guests that we've had on, has talked about why court cases now are maybe not covered as much as they used to be. But maybe that's not true. Maybe you're in there all the time with your teams and covering everything.
It is true that many, in particular, magistrates' courts and smaller Crown courts were traditionally covered by solo freelancers, and they would cover cases for the local papers. They'd be on what's called retainer agreements, where they get flat fees every month, and that would be for the local papers. Unfortunately, the retainer agreements were scrapped sort of in the late 90s, early noughties, which has since made it difficult for freelancers to exist in the courts. I mean, we still do the courts because we supply pictures as well, which does help when it comes to covering courts worthwhile. But sadly, those who don't do pictures will struggle, and inevitably many freelancers have either retired or just given up because we're living on fees which were agreed in the 1980s.
But you still, every day, have someone, don't you, at a magistrates' court,
yes.
or a number of magistrates' court across the northwest.
Yes.
And you do get some great stories every day from them.
Well, when I first started out 30-odd years ago, my first boss always told me that the best stories are always in the magistrates' courts. And the reason for that is a lot of it just reflects real life. Most readers will relate to cases that appear in the magistrates' courts, whether it be drink driving or neighbourhood disputes or family feuds. These are incidents which people relate to. The offbeat, the quirky, sometimes the very, very funny. You will get black comedy cases at the magistrates' court, which you might not necessarily get at the Crown Court. They're great courts to cover. I actually think, in my sort of 30 years of doing this, I actually think the courts are a lot more accessible now than they were about 20 to 30 years ago. I think we're getting a lot more access to stuff that we wouldn't have otherwise been. And I think also, in many cases, the press are not treated as the enemy. There has been anecdotal evidence of magistrates saying, wow, it's great to see you here, because we've not seen a single reporter in 6 months.
Yeah.
And that is quite sad, really. What we've found is that it's only in recent times that we've been covering the magistrates' courts in Cheshire and some in Merseyside, and a lot of them haven't been covered for many years.
When you're sending them to those, are you sending with a specific story in mind? Because you've seen something on the list. You're not sending speculatively.
No, it's always about targeting particular cases which I think are going to be interesting.
So you've seen the list and you go, there's something in that.
Yes, there's one this morning that we're having a look at about an 83-year-old man who's up for harassment and criminal damage to a neighbour's adjoining wall. So it's potentially quite interesting. He's 83, very unusual for an 83-year-old man to be before the court. He's accused of climbing over a fence and shouting abuse at his next-door neighbour.
We were talking to Mark about single justice procedure and is this pushing magistrates' courts hearings behind closed doors? Your view is slightly different, isn't it?
Yes.
Just explain why you're not as concerned about single justice procedure.
A lot of these single justice procedure cases are sort of very minor motoring matters. And I've seen these lists. They're freely available for any member of the press to pick up. And it's a bit like the old days of when you used to plead guilty by letter and you would then get 3 points on your licence and a £60 fine. These single justice procedures might be for people who perhaps have turned down the chance of going on a speed awareness course, but we're not talking about a scenario where people are facing a road ban or potentially very serious matters being dealt with behind closed doors. I suppose there is an argument to say, is this the slippery slope?
I think there's concerns over whether they're dealing with truancy that way, whether they're dealing with COVID fines that way, and whether then the list becomes
chunkier and bigger because, well, actually, is that minor? Should we put that in there as well? And I suppose that's the concern, isn't it? That if it grows.
I would be surprised if truancy cases were being dealt with by single justice procedure, because technically you can be jailed for truancy offences. There has been cases in the past where parents have gone to prison for not sending their children to school. But I have seen a number of single justice procedures, not just the one I showed you this morning. All of it is motoring, it's speeding or failing to produce documents.
So therefore, do you think it makes some sense in terms of making the court process more efficient?
Well, you've got to remember that courts aren't cheap to run. The argument will be, well, it costs about 750 quid to run a magistrate's court for a day. The view might be that, well, what is the point of putting on a special court just to have somebody say, yep, he was caught speeding at 40 and a 30, and I'm fining him 60 quid with 3 points on the licence? Because invariably, if you plead guilty by letter or whatever it is, invariably there won't be an explanation there. It will just be, yes, I admit it. You know, I throw myself on the mercy of the court or whatever it is they're going to say.
Yeah. But what are you worried about then, John? We know you have concerns.
My main gripes are, well, the minor one at the magistrates' court is that it's sometimes very difficult to get the first name of the magistrates, but that's by the by. The main gripes are some of the stuff that goes on at the Crown Court. What happens now is that courts will have something called a digital case system known as the DCS, which is a great invention. It's like a hub for prosecution, defence lawyers, probation officers, police, etc., to file various evidence, opening statements, sentencing statements, that sort of stuff. So the judge can read a lot of the papers before hearing the case. Great for them, but the trouble is there is an element of a double-edged sword about it, because if the judge has read the papers, which invariably they will have done, they'll come into court with an idea of actually what's going to happen. And you will get scenarios where the judge said, right, I've read the papers, can we get on with it, please, because you don't need to go into too much detail. So invariably, you'll get a scenario where the judge will have read the papers beforehand and come into court and will have an idea basically of what everything is about. And he may even have an idea of what sentence they're about to pass. But that is no good for a member of the public or a member of the press sat in court. And unfortunately, the effect of that is that we are then placed in difficulty about what we can actually report of a case if there's little detail. That then leads in turn to confusion in terms of the readership, who have no idea why somebody facing a serious criminal offence has in effect walked free. The other issue is the use of victim impact statements in court.
These were a bit of a revelation when they were introduced, weren't they?
Well, I think it's an American thing. What used to happen in these American courts is that people stand up and tell the court of what the effects are of the perpetrator's crimes against them. And what it does is it adds a human element.
When they're delivered by the actual victim or relative of a victim, they're really powerful.
Yeah, well, the reason why they were introduced is because it's so the defendant could actually hear them. That's the reason why they should be read out, is so that the defendant can hear what the effects are of the crime he or she has committed on the victim. Yes, there will be cases where some people will give those victim impact statements in person. Invariably, there'll be many occasions where they're not present in court to give their victim impact statements, yet they've still been written and they should still be heard. And there has been numerous examples where a prosecutor might refer to a victim impact statement and the judge will say, yeah, I've read it. And they'll go, right, we'll go no further then. And of course, then the defendant never hears what the victim has suffered in terms of a human element. And whilst the judge, I know, will take it into account, the victim impact statement, that is, when sentencing, it's still important that the defendant should actually hear what is actually said by the victim. One case that I covered, the judge says, I hope you read the report when you're in prison. Well, he may well have read the report, the defendant, but I suspect that person didn't.
Surely, if one of the intentions of victim impact statements was for the defendant to hear what the impact has been of their behaviour or their crime, was not quite fulfilling that intention, is it?
You feel like you're shortchanging the victim.
Yes.
Well, indeed, and I suspect the victim is writing it for that reason.
Yes. Some victims will actually specifically ask for their statements to be read out, and they will be. I think on the majority, you'll find that the prosecutor might do a very sort of watered-down version of the victim impact statement, just a couple of lines. And it comes back to that same argument. The defendant really should hear the full effects of what the victim has suffered.
What's the reason to not read them out?
It's nothing to do with trying to keep things secret. It's nothing like that at all. It is all about time. I understand why the courts want cases to be dealt with quickly, because they've got a huge backlog to get through post-COVID.
How often are you coming across it?
Certainly the anodyne sort of couple of lines, pretty much, probably about 70% of the time. You don't get to hear the full statements. There's one particular judge actually that sits, and he will actually read out passages of the victim impact statement, which he thinks are significant, when the prosecutor doesn't read it out. So, and it's very unusual that that particular judge does it, and it does explain. It helps me understand, and that means it helps the public understand, because we are known as the eyes and ears of the public.
There's a couple of occasions where I've sat through victim impact statements on a sentencing that come immediately to my mind. The wife of the police officer, Dave Phillips, gave me goosebumps, that one, in court. She was so eloquent, and it was very powerful.
But I'm guessing she gave that statement in person.
She did. She stood up in person.
Let's not ignore the importance of open justice, and let's get these statements actually read out properly as they're supposed to be.
Tell us, I don't know, best magistrates court story.
My favourite magistrates court case is still one.
I love he's got one off the top of his head.
I do. We did not prep him for this, and yet he has it.
No, it is still one from about 30 years ago. I was covering another case, and I had to go and do a door knock on it. And what happened was that I went for a pint at this particular person's local pub afterwards. And
keeping up those journalist traditions.
That's right. Yes, absolutely.
Glad to hear that.
It was a lovely little pub in Drax, near Selby it was. It was a real country pub, hardly anybody in there. And the landlord asked us who we were, and said who we were and what we were there for. And he says, "Oh, you don't need to worry about that load of rubbish. Why don't you come to our court case?" And obviously I was thinking, yeah, right, okay, here we go. It was in the days of strict licensing laws, and the landlord was up for serving people after hours. What was interesting about it was that the police sent in 3 undercover officers to expose this thing. But what was more interesting was that all 3 officers got absolutely sloshed during this investigation, one of whom was so drunk that he actually fell over whilst trying to, in effect, arrest this landlord. And obviously we went to cover this case. All the officers gave evidence, and they all had to admit drinking between 5 and 8 pints of Old Bailey beer, which is what they were serving Old Bailey, which is a very strong
brilliant
beer. The famous headline in the Daily Mail being "Passing Out Parade." Yeah, that was the headline.
Top marks to our subs there.
That was without doubt my favourite.
Thank you for coming in. Thank you for joining us. It's been fantastic to see you.
Great to have you, John.
We'll let you get back to court.
Well, it might be more a case of a coffee, or maybe something stronger, perhaps. Yeah.
Thanks.
Right,
thanks, John.
Thank you.
So that's it for episode 11. We'll be back next week, hopefully with some evidence about baby H, a baby girl who Lucy Letby is accused of attempting to murder twice in September 2015. Charges she denies.
I'll be in court to listen to the evidence, and you can read my daily reports in the Mail and on Mail Plus.
You can also follow us on Twitter at Lucy Letby Trial, or send us an email at thetrialoflucyletby@gmail.com.
And we'll both be back next week. See you then.